It's been an amazing undertaking because, first of all, with most cases, they don't have any type of publicity that this one has, and they don't have any social media presence. On occasion, you might look around and see what other people say about your case or what's happening in social media, but never have we had the type of attention or focus that this one has had. And of course, even more uniquely, never have we had a situation where we've actually involved ourselves to a certain extent in looking and watching social media, and to a small extent taking part in it. So it's very unique.
Do you think that it has helped or hurt your case here?
Oh, I think that if I could do away with all media, including all social media, that I would not have it involved in a criminal case, quite honestly. But that's a fantasy that is 40 years ago. With that, because the concern that I have, of course, is it has any potential for negative impact hurts a defendant. So I don't like that part of it. Yeah. But having said that, the reality is it is here to stay. So a good criminal defense attorney, any good attorney with a high-profile case is going to have to know how to handle it and know how to respond to it and know how to involve themselves in it to the extent that the ethical rules suggest it appropriate.
Sorry. Well, you've used social media to your advantage as a big fundraising tool for your client as well.
Sure, so, absolutely.
You can't really have it both ways, or can you?
Like I said, 40 years ago, there was no media in the courtroom. There's no question that in 2013, social media is here to stay, and therefore our involvement with social media and all media of all sorts is here to stay. So having said that, there's no question that we can take advantage of those opportunities. One, to look at the Gentile case and figure out how under those guidelines we can get our response to a prosecution, sometimes an over-prosecution, how to get that out to the public, because we're entitled as defense attorneys to do that. And very uniquely, we've used a website and social media to actually request or to at least have a vehicle for donations. Amazing, but I think even that's sort of here to stay.
What are you expecting to happen on Tuesday?
We have a number of hearings, a number of motions set. Two and a half motions for sanctions against the state for what I consider to be an extraordinarily frustrating amount of discovery concerns. So we're going to have to address that. The state has some issue regarding my client's decision regarding the immunity hearing. We may address that. And just basically, we need to also plan to the extent that we can with the judge what's going to happen in the next 6 or 8 weeks, because we have a jury to pick in what has been termed, I guess, and rightfully so, one of the most high-profile cases in the country right now, and that is going to impact on our ability to pick a jury, so we need some really good guidelines on that.
Before you made it sound like it was really that you were kind of behind schedule preparing for this case, or where do you feel like you are basically 8 weeks out?
Well, if I can have another 8 or 10 or 12 weeks added on top of it, there's probably that much more work to be done. Having said that, on the other hand, this is a case where the event happened in about 5 minutes. Strangely enough, it was recorded in a number of different ways, so the facts are available to us pretty quickly and pretty easily. If it wasn't for the intense coverage on this case, one, there might be the suggestion that Mr. Zimmerman may never have been charged. But having been charged, it would have been a case where we probably would have addressed this matter in a self-defense immunity hearing, and it would probably have gone away at that point. Realizing all of that, the enormity of the workload that we have is in dealing with some of the extraneous, peripheral information that has been generated by this case, and that's what's taking a lot of time.
Why is it important for you to have Trayvon Martin's cell phone records?
Well, because it's part of any evaluation that we do. Unfortunately, we can focus on, a deceased 17-year-old and say that we should completely respect the family in their loss. And I understand that. Having done this for my whole life, I represented victims in many, many cases. I represented defendants in many, many cases, and I understand the sensitivities of each. We live in an open society and in a state where there is very open discovery. And that open discovery not only allows us, but mandates that we do what we can to zealously represent Mr. Zimmerman. And just as the state went and got his school records, and the state went and did a complete download on his phone, we have the same rights. Now, is that an intrusion of privacy? As I said, if I could have it where there is none of that, I think it would help the system, and I think it would probably help individual criminal defendants. But we're not there, It is malpractice for me not to look at social media. It is malpractice for me not to take advantage of phone records that exist or information that is resident on a phone that we have subpoena powers over. So the question really becomes how you balance the sensitivity of a deceased person's family with the Sixth Amendment right to properly defend my client. And I think we're trying to balance that properly, but I also believe in my heart, and with 30 years of criminal defense experience, that the Sixth Amendment says I have an obligation to zealously represent Mr. Zimmerman, and that means to get to every piece of evidence that I can find.
Do you still want to talk to Mr. Crump, and what do you want to hear from him? What do you want to know from him?
It's very simple. Mr. Crump has intentionally made himself a very significant witness in this case. The fact that he is an attorney protects a certain amount of that. And quite honestly, we're not seeking to get after anything that is otherwise protected. If he wants to come in and say it's attorney-client privilege, he will and he should. If he says it's work product and that's accurate, then we can't get to it. But when you have an attorney, or let's just say he wasn't an attorney, who comes out and makes certain statements to the public, who presents a certain picture, which is at least seemingly a very focused view, if not an inaccurate view of the facts of the case. And then he says things like, I know that Norm Wolfinger and Chief Lee had a conversation that night and decided not to charge George Zimmerman. Well, those two parties who are supposed to have that conversation strictly deny it. I would like to know where he got that information from. Similarly, when he says Sanford Police Department is racist in the way that they handle a case and they didn't do this right, and I know that they said they were going to do this, that helps the defendant. So I want to know that information, and if Mr. Crump is the vehicle for that, then so be it. Most importantly, he put himself right in the middle of the investigation of a very significant witness and did it in a way that caused more questions than answered. I think you would probably agree, maybe not, that the way the interview was handled has caused more questions and more concerns than it answered. I would like to have the entire 25-minute tape that ABC had, because it listed everything that was said and everything that wasn't reported to have been said. Not having that affects my client's rights. So I'm frustrated about that, and Mr. Crump hopefully can answer some of those questions. That's why. A standing ground hearing is not proper. You know, that's one of my pet peeves. Self-defense immunity hearing is really what it should be called, because that's what the statute suggests. But the reality is we've decided not to do a pretrial for a number of reasons, and we'll sort of handle that as it comes up. We have a trial scheduled for June 10th. We'll sort of figure out how to present what we're going to present then.
Wouldn't that resolve your discovery issues, though? If you had the hearing, isn't everything that you're seeking discoverable at that hearing?
No, it doesn't resolve a lot of my discovery issues, because some of the discovery issues that we have are outstanding. Example was Mr. Crump is still a discovery issue. That's not resolved. Some of the frustrations that we've had that led to the motions for sanctions dealing with the delay in getting it. You know, I know that people have complained and said, well, just go do your work. And I get that. But when it takes me 6 months to get a picture of my client, full color picture that the state had day one, and first I get, and I know you hate hearing this, first I get the black and white, then I get the color copy, then finally after motion and order, we get the actual picture. If that doesn't speak volumes to the media, then you need to look closer. Because if I were to do that, look closer at me, because that's not the way you're supposed to handle discovery in Florida. Prosecutors and defense attorneys are supposed to seek justice, not just convictions or acquittals. And hiding the ball is not the way to handle any case, never mind a high-profile case.
What was the prosecutor saying that he just was inappropriate for anyone?
Oh, in my recent response? Oh, I don't know where to begin and where to end, but my understanding of both the case law, our rules of ethics, our rules of professionalism suggest that we are not supposed to take personal attacks to anyone, the judge, witnesses, defense attorney, or the prosecutor. And I think that there's really good reasons for that. This is already enough of an adversarial process. And what we really want to do is try and keep some semblance of sanity and justice, and most importantly, the people's respect. Because I have to imagine that anyone who would look at that pleading and say, this is the way lawyers treat each other, would say, I have no respect for this system if you can say what was said in that pleading, and that's the way they treat each other. Rather, I think we have to maintain the respect of the courtroom and the respect of the profession, because we have taken on an enormous responsibility as lawyers. We tell people to believe in us, believe in our system, come to us with your grievances, and we will respond to them properly and we'll resolve them properly. A pleading like that just tells them that we're in a sandbox throwing dirt at each other, and it demeans my profession, and it demeans the process. So that, were that to continue, that no matter what happens on the trial, people might not believe that a just result was accomplished, whatever that result is, if they lose respect for the lawyers or for the process.
Real quick, what's the
Last
impact
question.
of Mr. Zimmerman being in court on Tuesday? What do you need him there for?
Well, it's funny, the state has now requested his appearance. We had already decided a couple of weeks ago, because we had waived his appearance at the last few, that because of some of the significant issues we're going to address at this hearing, that he was coming anyway. So I don't consider it to be particularly significant. It's actually usually more significant to waive your client's appearance, but because of the security concerns and just the focus on this case, we had done that in the past. So my plan is that he'll be there, and we'll see if there's going to be any inquiry at all.